Welcome to those of you that have joined us. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Good morning and welcome to those of you that have joined us. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined us. We have just opened the live link, so we're just going to wait for everybody to join us before we start. Whilst we are waiting for people to join us, I shall just remind you of the house rules. So just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screen, and our speaker will try to come to those at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to remind you that we now have a separate section on the Five Stone Buildings website where we post the webinar, so you'll be able to catch this recording and any slides used and any previous webinars that have taken place. I will now hand over to Emilia.
Thank you very much, Jo. Thank you for me today to discuss a highly relevant topic, secret trusts. They're one of those very strange contrivances that amounted to a whole topic at law school. So you expect them to pop up much more than they actually do when you start practice. And while they're rare, they're certainly not unheard of. So today I'm just going to give you a quick rundown of what secret trusts are, some of their peculiar features and some problems which arise in respect of them, a summary of some recent cases that have arisen in the field of secret trusts, and then consider whether they have any relevance to today's society. So what are secret trusts? A secret trust arises when the testator, X, dies, leaving property to Y, also known as the primary donee, but Y, the primary donee, has separately undertaken that he will hold the property on trust for Z, the secondary donee. Now, there are two different kinds of secret trust: fully secret trusts and half secret trusts. Fully secret trusts can arise on a will or an intestacy, and there is no reference at all to the trust on the face of the will. So it's simply couched as an absolute gift to the primary donee, or if on it intestacy, it simply passes to the intestacy beneficiaries. Half secret trusts are different in that these make reference on the face of the will to the fact that the property is to be held on trust, but it's silent about the terms of the trust or the beneficiary of the trust. So for instance, the property is left to Y on the trusts which he knows about. And these obviously can't arise on an intestacy. Now, the main peculiarity of secret trusts is that they are upheld notwithstanding that they don't comply with the formalities of the Wills Act 1837, in particular section 9, which requires a will to be in writing and to be executed in a particular way. So refusing to name the ultimate beneficiary or to indicate that there is a trust on the face of the will means that secret trusts fall outside the Wills Act. So why are secret trusts enforced? Fully secret trusts were upheld from around the late 17th century and then adopted with gusto in the 18th century. And when first faced with secret trusts, or where it was evident that the testator had devised or bequeathed property to Y, and then Y had undertaken to hold it on trust for Z, but there was no reference to this in the testamentary document, the courts could have gone one of three ways. They could have held that Y took absolutely and there was no trust. They could have held that Y held the property on resulting trust for the testator or his estate, or they could have taken the route that they've chosen to adopt, which is that Y holds the property on trust for Z, the person that the testator ultimately wanted to benefit. Now, initially, this was done reliant on the maxim that equity will not permit a statute to be used as an instrument of fraud. And this was used to enforce fully secret trusts, but the courts were much less keen on half-secret trusts, which were not definitively held as enforceable until the House of Lords decision in Blackwell and Blackwell, where the testator gave some money on trust to people to hold the income for the purposes indicated by me to them, with power to pay over the capital sum of £8,000 to such person or persons indicated by me to them as they thought fit. And there was evidence of the detailed parole instructions that had been given to one of the 5 trustees. And again, the trust was upheld partly on the basis that a legatee cannot profit from his own fraud. And that was generally the original justification for secret trusts, that equity will not allow a statute to be used as an instrument of fraud. Now, this is a locus of academic debate, which I'm sure you all covered at law school, and I don't want to go into it in great detail because its practical implications are not that helpful. But generally, the fraud theory has gone out of fashion, partly because it's not clear who the secret trustee is actually intended to be prevented from defrauding. Is it the beneficiaries that they cannot defraud, or the testator? And it also doesn't work in the same way for half-secret trusts because the trustees are clearly stated on the face of the will. So the prevailing theory now is that secret trusts operate outside the will, or dehorse the will in that awful French, legal French. So, sorry, could you go back to the previous slide, Joe? Thank you. So in that case, X's will gives the property to Y, and the fact that Y is directed to hold it on trust for Z isn't a matter of succession law, but it's a matter of the law of trusts. But again, this is difficult because a secret trust is still a testamentary disposition that doesn't come into effect until death. So this is also questioned by editors of Parry and Kerridge, for instance. It's not, while it's a prevailing theory in relation to people like the editors of Lewin and Snell, it's still not one that's definitive. And there isn't really a definitive answer as to why secret trusts are justified, because there still isn't an explanation as to why they are permitted if they operate outside the Wills Act, not just outside the will. Could you go to the next slide now, please, Joe? So what are the basic elements required to establish a secret trust? Firstly, you need an intention by the testator to create a trust. Secondly, that trust needs to be communicated to the intended trustee. Thirdly, the intended trustee needs to accept the trust, either expressly or by implication. And finally, the trust has to comply with the 3 certainties. Now, half-secret trusts have additional elements that need to be complied with, which are on the next slide, please. And these relate expressly to communication of the trust. So in respect of the half-secret trust, it must be communicated to and accepted by the trustee before or at the time the will is made. Whereas in the case of fully secret trusts, the trust can be communicated to the trustee at any time up until the settler's death. And in addition, communication of the trust must be consistent with the will's description of it. And that's why in Re Keene, the secret trust failed. Now, one of the most recent cases on secret trusts covered whether a secret trust was a half secret or fully secret trust, and that's on the next slide, please, Joe. So this concerned the estate of the painter Lucian Freud, who had a £42 million residuary estate, which by clause 6 of the will, he gave all the residue of my estate, out of which will be paid my funeral and testamentary expenses and my debts, and any property over which I have a general power of appointment, to the said Diana Mary Rawstron, his solicitor, and the said Rose Pierce jointly. Rose Pierce is one of his daughters. And there was a question as to whether on the construction of the will, this gave rise to a half secret trust. So on the face of the will, there's reference to the fact that there's a trust, or whether it gave rise to a fully secret trust. So the property was given to the Mrs. Rawstron and Ms. Pierce, absolutely. And this was a question of construction. Now, the claimants, who were also the executors, Diana Rawstron and Rose Pierce, contended that it was an absolute gift to them, and they also accepted that they held the residue on fully secret trust, so the terms of which were not disclosed. The defendant, however, was one of Lucian Freud's many illegitimate children, and he argued that on its proper construction, the will didn't give the residuary estate to the claimants for their absolute benefit, but instead for them to hold on trusts which are not set out in the will. And on that basis, the trust imposed on the residuary estate would be a half-secret trust. And because as we've seen, half-secret trusts needed to be communicated to the trustee before, at the time the will was made, and the defendant said the communication was in fact made to the secret trustees after the will was made. If it were a half-secret trust, then it would be invalid and fall on an intestacy, and because he was a child of the deceased, he would benefit on an intestacy when he wouldn't if it were a fully secret trust that would be valid. And this was essentially a matter of construction, which is difficult because on the wording of the clause, there was no express reference to the residue being held on trust. It wasn't expressed to be made beneficially or absolutely, but it wasn't said to be on trust. And what the defendant said is that it was given jointly, which must have meant on a beneficial joint tenancy, which can't have made sense. So it couldn't have been given to them absolutely, it must have been given to them on trust. And they also said, the defendant also said, that the factual context supported the contention that it was to be held on trust. For instance, that the first claimant was the testator's solicitor, and she wasn't permitted under professional conduct rules to accept an absolute gift under a will that she had prepared for her client and would have been struck off otherwise. But the judge, looking at the terms of the will, the whole of the will, considered that it was an absolute gift to the claimants and not held on half-secret trust. And he was also particularly swayed by what he called the striking feature that the previous will was made by Lucian Freud, had in it a clause that was plainly intended to create a half-secret trust. And in the will that was the subject of debate, there was no longer this wording. So the only reasonable conclusion to be drawn from that change of wording was that the testator had not wanted to create a half-secret trust. So next slide, please, Joe. In that case, in the Freud case, it was accepted there was a secret trust. But if there's a debate about whether there is a secret trust, and if you want to prove a secret trust, how do you go about it? Well, the burden of proof is on the party who is alleging the secret trust. This will usually be the beneficiary, but can sometimes be the trustee or some other person, and the burden is always on them. Generally, the standard of proof is the balance of probabilities, and that's said to be in the absence of fraud or special circumstances. But it may well often be the case that if a beneficiary or an alleged beneficiary is trying to prove that the alleged secret trustee has received the property and has taken it for himself rather than as a trustee, then by necessity, they might be having to prove that the trustee is fraudulent. So arguably in those cases, the higher standard of proof relating to fraud is necessary. Next slide, please, Joe. Now, many of the recent cases in respect of secret trusts have relied on whether there was an intention to create a secret trust, which generally aligns with the similar principles surrounding the intention to create an express trust in accordance with the three certainties. And the question you need to ask is whether the testator has intended the sanction for non-compliance with his wishes to be the authority of the court or simply the conscience of the donee. If the former, then they're probably a trustee. If the latter, then it's probably a moral obligation. So it may well be the case that the testator has asked the alleged secret trustee to look after the alleged secondary donee or beneficiary, but it has to be demonstrated that that's an enforceable trust obligation rather than simply a moral obligation. And in terms of words like look after, it's been found that the more uncertain the terms of the obligation, the more likely it is to be a moral obligation rather than a trust. So, for instance, in Casper Baron Griffith, a general understanding and a reference by the testator to the alleged trustee knowing what she had to do indicated only a moral obligation rather than a legally enforceable duty. And similarly, in that case, there was evidence that the testator had changed his mind about what he wanted the alleged trustee to do, and the intention needs to be settled. In a case that I had to consider about secret trusts, the testator told the alleged trustee to share it out to whom she chooses of her choice. And there was a question as to whether or not that's sufficiently certain. Obviously, and as is usual in litigation, these kinds of issues arise when things aren't written down and you have to rely purely on oral evidence. So if a testator does want to set up a secret trust, it's much better to have an express memorandum alongside their will that demonstrates their intention, not least to prevent the trustee fraudulently taking the gift for themselves. Next slide, please. Now, quite shockingly, there have been two relatively recent cases that have gone to trial concerning secret trusts, and both of them concerned proving secret trusts and what the factual evidence required to prove a secret trust has been. Now, the first was decided last year in 2021, I think January, in the High Court before Deputy Master Rees. And it arose out of a claim brought against the sole beneficiary of the estate of a Mrs. Richards, who died in Monaco during in 2015. And by her will, she left her entire estate to her close friend, Mr. Eisen, the defendant, who had cared for her during her terminal illness. And the claimant, Ms. Titcombe, is the niece of the testator. Now, included within Ms. Richards' assets at the date of her death was a collection of jewellery which had been valued in 2017 at approximately £150,000 to £200,000. And the claimant contended that the jewellery, which pursuant to the terms of the will vested in Mr. Eisen, was in fact impressed with a secret trust in favour of Ms. Titcombe. And interestingly, in the alternative, she argued that if the secret trust argument failed, Mr. Eisen was stopped from denying that the jewellery was held by him for her benefit. So she ran an argument of proprietary estoppel as well. As we've seen, the burden was on her, Mrs. Titcombe, to establish a secret trust. And one of the things the court had to do that we've seen in the last slide was to determine whether it was a trust or whether it was merely a moral obligation. Now, the claim to a secret trust failed because the arrangement between Ms. Richards, the deceased, and Mr. Eisen amounted to no more than a mere moral or family obligation, which was not intended to be enforceable by the court. It relied very heavily on oral evidence, Ms. Titcombe's case. In particular, she said that the trust had been created in a Skype conversation that had taken place between her, Mr. Eisen, and the deceased, in which the trust was communicated and accepted by Mr. Eisen. And the court considered that it was highly improbable that such a conversation had ever taken place. And it in fact considered that no conversation about the jewellery had taken place. Her claim for proprietary estoppel also failed because there had been no statement of intention on which she had relied vis-a-vis the distribution of the jewellery. And in any event, she wouldn't suffer any detriment for the purposes of proprietary estoppel. The alleged detriment, interestingly, was the loss of a tactical advantage in challenging the will and stymieing the administration of the estate. But the court held that that wasn't a detriment since Ms. Titcombe was still able to bring a claim to set aside the will if she so chose. Now, interestingly, there's a pleading point here in that the parties alleging existence of the secret trust must plead with specificity the date on which the secret trust is said to have been created by words in writing or otherwise. So in this case, she pleaded that it was during this Skype conversation, and that's a lesson for the future. If you ever need to prove a secret trust, you need to plead exactly when the secret trust is said to have been created. Next slide, please. Now, this is the second recent case on secret trusts, which was decided, I think, last December in the High Court. And again, was very much a factual investigation as to whether a secret trust had been created. Now, in this case, Kim Mattingly, the deceased, had died in 2020, and the claimant was her daughter, and the defendant was her administratrix and her sister, so the claimant's aunt. Under her will, she had left her residuary estate to the claimant, but there was in fact very little or no residuary estate. And it provided that her interest in the property and certain effects within the property were to be devised absolutely to the defendant, Karen Bugager. Her will also expressed a wish that the defendant allowed their mother to live there for the rest of her life. But in fact, at the time of the will, the mother was residing in the property pursuant to a 25-year lease. So the deceased at the time of her death had a beneficial interest of 71% in the property pursuant to a deed of trust. Now, the claimant had alleged that her mother, the deceased, and Karen, her aunt, had agreed, and Karen had promised that on the deceased's death, Karen would hold a 26.625% interest. I can't remember exactly why it's such a specific interest on trust for the daughter. She said that this promise was made before the 2016 will. And the defendant, Karen, denied that any such agreement or promise was made. She said that the only comments made to her by the deceased were to the effect that she didn't want her estranged husband to receive an interest in the property. She wanted to ensure that the mother could live there for the rest of her life. And if the mother went into care, then she wanted the property to be sold and the proceeds used to pay for the care. She had accepted that once the mother had died, the property and its proceeds would be divided between her and the daughter, Annabelle, but said there was no legal obligation on her to do so. And similarly to Titcombe and Eisen, the judge found that Karen simply had a moral obligation. The claimants had said that her solicitors, the deceased solicitors, had questioned whether the claimant was to have an interest in the property. And the deceased had said, oh no, it's going to pass to Karen. And the claimant said, oh no, that's just the public response to the solicitors. In secret, she had said something else to Karen. But interestingly, the judge said that Kim was like most lay people not knowing about secret trusts, and so considered that legal obligations would be imposed by the will or not at all. And this wouldn't be incompatible with a secret trust, but it's likely to be unusual. Generally, they found that the claimant's written evidence smacked of being influenced by documents and outside sources. And when she was actually giving oral evidence, her claim that the deceased had created a trust was actually much weaker. And it was, in fact, simply a moral obligation rather than a legal one. So again, these kinds of cases are really fact specific. And as with many of our areas of work, documentary evidence is critical, and you cannot fall back simply on oral evidence. Next slide, please. So I'm now going to consider a couple of interesting problems in respect of secret trusts that have arisen. The first is what happens if the secret trustee dies before the testator. So usually, in respect of a will, if the gift is beneficial and the beneficiary predeceases, the gift lapses and falls into residue. If the gift is left on an express trust, the trust doesn't fail because equity will not allow a trust to fail for want of a trustee, and a trustee will be appointed in the deceased trustee's place. That's relatively straightforward. In the case of a secret trust, it's not quite so straightforward. It's been suggested in Maddock that in the case of a fully secret trust, the gift fails. And in the case of a half secret trust, the gift would survive because on the face of the will, it's expressly said to be left on trust. So again, because a trust will not fail for want of a trustee can be appointed in the deceased trustee's place. It's not clear why that doesn't apply to fully secret trusts, because even if the trust isn't specifically referred to on the face of the will, the fact is that the gift is still held on trust. And so presumably there is still a trust, and which cannot fail for want of the trustee. Obviously, this hasn't been tested because there are lots of practical problems. Who would take over, as somebody else needs to know the terms of the trust, which is meant to be secret. And again, you would require there to be some kind of express memorandum provided with the will if it's prepared by a testator. Next slide, please. Another issue which has actually arisen in practice for me is what happens if the secret trustee witnesses the will. Now, Section 15 of the Wills Act states that any beneficial devise, legacy or gift by will to an attesting witness or to the husband or wife of a witness shall be utterly null and void. And in my case, the testator's sister was the sole beneficiary under the will, but the will had been drafted by her husband. So the gift to her was prima facie void and fell on intestacy to the testator's estranged children. But the sister then said that in fact she wasn't holding it absolutely, she was holding it on secret trust for other beneficiaries that weren't herself. And it seems relatively clear that it's the case that where a beneficiary under a secret trust attests the will, he won't forfeit his interest because his rights aren't derived from the will itself, but they're derived from the trust. And that's what was found in Young. it's also the case that a non-secret trustee witnessing a will doesn't mean that the gift is void, because they're not receiving the gift beneficially, they're receiving it as a trustee. Now, on that principle, Lewin says that if a half-secret trustee witnesses the will, that doesn't void the gift. And I think that's relatively uncontroversial, but there's no consensus about whether that principle applies to fully secret trusts. So on the basis that secret trusts operate outside the will, and the will is only relevant insofar as it completes the constitution of the trust by vesting the property in the intended trustee, it could be argued that the secret trust can only be engrafted onto a valid testamentary disposition, otherwise it can't be constituted. And in the case of a half-secret trust, because the gift is to a trustee on the face of it, the property can vest in them. But in the case of a fully secret trust, the gift is prima facie to the beneficiary only, and therefore must be invalid. The property cannot vest, and the trust can't be constituted. Now, you have to subscribe to the view that secret trusts operate dehorse the will for that to work. Otherwise, there's not really any reason why there should be a difference between a fully secret and half-secret trust, because either way, the property is held on trust, not beneficially, and so should fall outside the mischief of the Section 15 of the Wills Act. So it's a question that's not fully settled, as are many issues with secret trusts, and hopefully it can be tested at some point in the future. Next slide, please. Now, given that there are all of these difficulties with secret trusts, proving secret trusts, the legal mechanics of secret trusts, there's a question as to whether they have a future at all. Obviously, this is now 20 years ago, but there was a survey published in 2003 in Conveyancer and Property Lawyer of 86 respondent solicitors who all specialised in wills and probate. And they were asked whether they had had a client who had asked them about making a secret testamentary behest, and 35% of them said that they had. So that's not a negligible amount. So that's over a third. In respect of these secret gifts, 16% of the respondent solicitors had been involved in the creation of fully secret trusts, and 20% had been involved in the creation of semi-secret trusts. Now, again, that's not incredibly high, but it does indicate, as does the case of Freud that we saw earlier, that secret trusts are in use, and there is still a need for them. I can't vouch for whether this is still the case today, but I've certainly seen secret trusts appear in my practice. Next slide, please. So there is a question as to whether there is a need for secret gifts, and whether secret trusts are the best way to implement them. 77% of the respondents to that survey thought that there might be circumstances in which a client might wish to make a secret gift. And there are a variety of circumstances in which a secret gift might be necessary, or at least desirable. So for instance, the classic example, making gifts to people who the surviving family doesn't approve of or know about, a mistress or an illegitimate child. Again, in the case of family conflict, it might be thought that secret trusts could cause problems and further litigation. But thinking about it, a gift to a secret beneficiary might well be less likely to be challenged if the surviving family doesn't know about it, particularly in cases of family conflict, and as long as the will is prepared by a qualified solicitor and it's clear what the terms of the trust are to the trustee. They're also used not just to conceal the beneficiary from other potential beneficiaries, but they can also be used to conceal the nature and the extent of the trustee's powers from the beneficiary themselves. So you don't need to include all of the terms of the trust within the will. Now, in the survey, some solicitors raised whether they could be used to prevent state benefits from being lost, but that is obviously not a recommended approach, because that is illegal. And there's a question relatedly to that, which still hasn't been answered, as to whether secret trusts can avoid inheritance tax. And this was a question that was raised in Carslaw and Griffith, where the testator left his property to his wife, and the children said there was a secret trust. And as to whether that means that it benefits from the spousal exemption without having to report it to the revenue. And whether the primary donee, the trustee, can give effect to the testator's intention without making a transfer of value for EWHC purposes, for instance, and without complying with the Inheritance Tax Act constraints. So that's the question that still hasn't been answered in the case law, but it's interesting to see whether and how it would work. Next slide, please. So given that there is this variety of circumstances for where it might be desirable for there to be secret gifts, secret trusts seem to be, at the moment, one of the most effective and well-known ways of doing this. However, if a testator does wish to create a secret trust, then they must be very carefully drafted to avoid the issues that arose in, for instance, Freud. And a practitioner must preserve evidence of the beneficial interests that are going to arise under it, and compliance with the condition of such trusts. Generally, the courts have urged against using secret trusts. So, for instance, Sir Raymond Evershed, Master of the Rolls, said in the general public interest, it is desirable that if a testator wishes their property to go to their solicitor and the solicitor prepares the will, that intention should be plainly expressed in the will and should not be arrived at by the more oblique method of secret trust. Now, instead of a secret trust, one of the possibilities could be for there to be a kind of, it's sort of a semi-secret trust in a way, but to have a broad discretionary trust, a flexible discretionary trust with a private letter of wishes that would not need to go to the probate registry and therefore be public, but could still achieve some of the aims that testators seek to achieve by using secret trusts. I think that's all I've got to say about secret trusts today. I think I've run slightly over. I was meant to be half an hour, so I'm not sure I've got time for questions, but please do drop marketing at 5sblaw.com an email if you do have any questions that you'd like to ask. And thank you very much for listening.